Postal Resources Management Council semi-monthly meeting to order. Today is Tuesday, November 14, 2023. Would ask that the record reflect the council members in attendance as well as staff members that are in attendance. First matter on our agenda would be approval of the minutes of the previous meeting, that being October 24, 2023. I know that they have been sent out and disseminated. Are there any corrections proposed or a motion to accept?
Acceptance.
Motion has been made by Mr. Gagnon to accept, seconded by Mr. Gomez. Any discussion? Hearing none, all in favor say aye. Aye. Anyone opposed? That motion carries. Subcommittee reports or staff reports, Mr. Willis?
One subcommittee report, Mr. Chair. The Planning and Procedure Subcommittee met tonight to propose some changes to its beach vehicle regulations. Those were accepted by the P&P members to begin rulemaking. So we will begin that process with the Office of Regulatory Reform and get that in motion so that they come back to you in time. As for a staff report, there is not a staff report tonight, Mr. Chair.
Okay, thank you. First matter on our agenda will be applications that has been out to public notice before the council for review and action, that being 2023-05-053 Mark and Cheryl DeMELLO. It's an application to construct and maintain a residential boating facility consisting of a total 188 feet in length, terminating at 50 feet beyond mean low water, and requiring a variance to the side setback standard section 1.3.1D 11K. It's located at plat 25, lot 45, 395 Park Avenue, Portsmouth, Rhode Island. And Mr. Willis, if you can address the council on this application.
Mr. Chair, this morning we received an email from the town administrator of Portsmouth asking that this matter be continued. The town administrator has asked that so that he can have his staff look into this application relative to the town's harbor management plan in a little more detail. Apologize for the late notice, but when a town asks for a continuance, it's something that we take seriously. We defer often to the town because their scheduling might not coincide with our public notice for this for any particular matter. So we have regularly granted continuances, and that's what this appears to do, although the town is apologetic for a last minute request.
It's my understanding that the applicant does not have an objection to the continuance. Is that correct?
That's correct.
All right. And just for the record, if you could identify yourself as the answer of that question, please.
Mark DeMello.
Okay, thank you. And it's my understanding that we should be able to get this on our next scheduled calendar date, which is 2 weeks from tonight, which is November 28th, 2023. And that would work for you and your expert, correct?
Yes.
Okay. So I would entertain a motion to continue the matter to our next scheduled date of November 28th, 2023. Mr. Flynn has made that motion. Is there a second? Mr. Rossellino, Ms. Cole has, I think it was Ms. Cole, it was Ms. Reynolds. Okay. Seconded it. Any discussion? I'll now poll the council. Mr. Rossellino?
Aye.
Ms. Hall?
Aye.
Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
Mr. Flynn?
Aye.
Mr. Izzy?
Aye.
Mr. Gomez?
Aye.
I too, Raymond Coyer, vote aye. So unanimously, the vote is to continue the matter 2 weeks from tonight to November 28th, 2023. And thank you for your consideration.
Appreciate it.
All right. Brings us to the next matter on our agenda, which is an application that has been out to public notice before the council for discussion, review, action, or referral to the CRMC Hearing Officer based on objections received regarding the application. That is 20-04-37. It is John Bowen and Patrick Bowen. It's an application to establish a 0.97 oyster farm using submerged cases in Sappoet Cove, Tiverton, Rhode Island. And I would ask Attorney DeSisto to address the council on the application as to its status and procedure.
Under section 46-23-20, all contested cases shall be heard by the administrative officer. And in this instance, the administrative officer is on board now, been appointed by the governor and sworn in, and is actually on the state payroll. So the question is whether or not this is a contested case for purposes of that statute. And I would direct your attention to 650 RICR-10-00-1 and subsection B. Contested case means a proceeding in which the legal rights, duties, or privileges of a specific party are required to be determined by the council after an opportunity for hearing. A proceeding before the council shall be considered contested when a substantive, formal, written objection and or request for hearing is received by the council from any interested party. Further, a proceeding shall be considered contested upon request for a hearing by any four members of the council. At issue today is whether or not substantive, formal, written objections have been received in regard to this application. Mr. Chairman, I'd like to defer to the executive director on that issue so that the council can make a determination as to whether or not this is a contested case that should be referred to the administrative, to the hearing officer.
Okay. Mr. Willis, please.
Thank you, Mr. Chair. So I've sat down with staff over the course of the staff's review on this application. And of course, we've received numerous objections to it. In looking over those objections, I noticed that there's several that could rise to the level of being substantive in accordance with our management procedures. And those primarily, in my opinion, would conform to section 116G C, subsection C, which calls out that the proposed activity or alteration has a potential for significant adverse impacts on one or more of the following descriptors of the coastal environment. And there's 9 descriptors. Number 5 is scenic and or recreational values. And I noted in those objections that there are a number of objections that raise the scenic impacts, that raise the impacts to recreational values in this area. And they're not just, in my opinion, pro forma. It's going to impact the scenery. It's going to impact the scenic value. It's going to impact my recreational use. A lot of these objections rise to, in my opinion, to be substantive because they call out instances of how the application might be significant to enjoy those scenic values or those recreational values. So in my opinion, I would recommend that there are a number of objections that have risen to that level and could be determined to be substantive if you all agree.
Any
Do
questions?
you have any other examples besides the scenic view thing, which is, in my opinion, not substantive?
Well,
Give me a break. It's a 0.9 acre piece of water with gear that's not going to be totally visible in an area that staff has worked very hard to come up with a layout for that plan, which I think they called the blue matrix or something on the zone, and they own property going right down. There shouldn't be any. I mean, you're talking miles of river, and you're talking about people that are now selling lots down the road a half a mile for houses right next to the state land. That to me is a substantive. But a 0.9 acre piece of water. Other people claiming riparian rights too. Tiverton claims to have a harbor plan that takes, avoids the placement of, or denies the placement of such and such a farm. And, we just keep getting into areas where there's a lot of innuendo and really stretched truth on some of these prohibitions, some of the things that are going to bother them. Like, for instance, cohoggers. Well, nobody cohogs there because they all cohog off the end of the stream that comes out under the bridge and to the north. Nobody cohogs there. Nobody fishes there. Nobody hunts there. And it's very well, in my opinion, sheltered, and I don't see any adverse impacts to the scenic beauty of that place. We don't, in CRMC, in my years here, we don't pay too much attention to view rights, for instance. There are certain places that CRMC picks out. I think maybe Secunda Point, there's one, there's a few areas that your documentation maintains that there's a view there that's important to save. There is no such view here. There was no such view when we put we allowed a farming application up near Jack's Island. And, then we had all the same hurrah, ospreys were going to get caught in the gear. We're going to lose eagles. I mean, it was stupid. But we passed that. I don't see a lot of difference, and I don't see
It's
any
in the red
impact.
book.
I don't see any impact. I'm talking.
It's in the red book.
I'm talking. I don't.
It's not your opinion,
It is
it's in the red book.
subjective. I think scenic view is a
Stop.
subjective thing. And maybe that's why it needs to go to the officer, but I just don't see it. And if we had done this 3 months ago, we wouldn't be in the position even talking about it. So my opinion.
Want to address that?
Well, Mr. Gomez, thank you. The reason why I brought up scenic and recreational values is because that is the one of the criterion of the 9 that are listed. That of the 9, I think number 5, scenic or recreational values, is the one criterion where a number of objections, in my mind, address the impacts to a level that could be substantive. So I understand your point on scenic, but it's lumped in with recreational values as well.
Nobody uses that area of the beach. I've been there several hundreds of times. I go there several hundred times a year, and nobody uses that section of beach except people that think it's okay to put a mooring in because they have riparian rights, which they don't. And everything that we worry about relative to activity, hunting, fishing, walking on the beach, it's all on the other side of the creek or across the bridge to the east. It's not in that section whatsoever. Ever.
And again, I appreciate that, but based on the information that came in these objections, that's where I'm basing my recommendation. I think your position is definitely one worth vetting here at the council to bring in that perspective, because the perspective I received in the written objections is where I'm making my basis from.
I'd like to, when we're done discussing, I'd like to hear Tony on that.
Okay, but I think Ms. Hall.
Yes, Ms. Hall.
I have a couple of questions. I think they might be for legal counsel, or the executive director. First, I based on 1.1.6G substantive objection, the standard is that evidence is presented, which demonstrates one of the following. So it's not a judgment call on the evidence, it's that evidence is presented. And then those factors are fact-based, based on the review by the experts, which is the staff. Its evidence is presented. So that is a fact-based question, I believe. And that's based on the staff's review. And this staff member has already indicated in its report that they're substantive, and that's a fact-based inquiry. And so and correct me if I'm wrong, Counselor, I think that's a question that's not our question. That's the question of the staff, and the staff's executive director has discussed that with the staff. They've reviewed the details of not only the application, but the hundreds of letters. and have found evidence presented on these fact-based inquiries that are listed in the regulations. So I think my first question is it really up to the council? I don't know where there's the council's authority to even weigh in and decide that. I think it's already been decided by the staff, which has determined that because they're fact-based, and by the executive director, who has agreed that that's the case. So I'm wondering if that's even something we have to decide, because I don't see authority here that says that's our job. And it could be that I'm missing it, but I don't see that being something that's our job. I think that's already been done by the staff, and it's all based on their expertise. And that's what this is. That's what those standards are. It's if evidence has been presented. It doesn't weigh in. It doesn't make a value judgment.
No, I understand, and that's
It's
why I
a
wanted
simple,
Tony to,
factual.
I wanted the
assessment.
council to speak on that, so you make a good.
And then I
point.
have a second question after that.
Would you like your
Yeah,
question
it'd be very
answered first before we
interesting. Yeah,
proceed to the
thank
second?
you, Thank you.
Yeah, I think it's appropriate for the council to actually refer the matter out. This application has been pending at this level for some time. And it's ready to go. The hearing officer is on. So I think that at this juncture for this application, it is appropriate for the council to make the determination that yes, based on the staff, and you've heard from the executive director, that this matter is appropriate to be sent to the hearing officer.
Great. So, but my question, I think I don't dispute the substantive answer with respect to how this will end up. I think procedurally, I just don't know that the council has that authority. I think that's the question. Maybe Director Willis can clarify that for me.
Before he does, this is a situation where the hearing officer has been appointed.
Yeah, I agree.
And this was an application that had been pending.
100%.
So that, well, procedurally, the way that I view this, and I'm giving you that advice, is that because of the procedural posture of this application, that it's appropriate for the council to make that determination based on what the staff has.
So the council has authority only because of the facts of the timeline of this case, or do they have it in their rules somewhere?
Okay, Jeff is
Chomping at the bit.
is gonna elbow me out of the way, so
Thank you.
there you go.
So thanks, Ms. Hall. Your point raised that should it be at the council at all is probably, and forgive me, is answered, not answered, but brought up, prefaced by section 151F of the management procedures,
Yes.
which says in part that if the council receives a formal written objection and or request from a hearing and is substantiated by genuine and material reason as outlined in 20-00-116G that we've been referencing,
Mhm.
the matter shall become a contested case, period. In 148, however, the headed contested cases, the very first phrase of the first sentence says, whenever the council determines that an application has become a contested case. So that's where I base my position on. Staff makes a strong recommendation on whether a matter could be, or whether an objection or objections could be considered substantive, but the council determines whether or not they are, and in fact, does the application become contested.
Right, and then in management rule 1.1H, the council is defined as individual members,
Understood.
subcommittee,
Mhm.
its staff, agents, or employees. So it's not determinative that it's the council. And I think, 1.4.8, when it says when the council determines that, I mean, that's a judgment call I think that we can make as to whether it's this council or you as the council, because it does, your own rules contemplate that it's individual members as well.
And I agree that these sections need to be stitched together better because this exact discussion that we're having.
So in this case, it seems that it could be either the council or you acting as the council could decide. And we, as this appointed body, have no role in deciding, aside from Attorney DeSisto advising us to do so. Is that correct?
Well, here's the thing. I don't see how there will be any procedural defects if the matter is referred to the hearing officer by the council.
Or by the executive director?
Yes,
I guess
but
I'm thinking
I'd
about going forward as this becomes a matter of precedent. It would just be a matter of precedent going forward, now that the hearing officer is in place, now that we have this moving forward. I think I'm thinking about it as the next case comes forward. Are we always going to have a council decision on questions of fact that the staff has already weighed in on?
This is a unique case. And I think that one of my concerns is you can get balled up procedurally on exactly what happens here. This matter has been pending before the council. Now there's a hearing officer. The staff has said there's substantive objections. So I think it's appropriate, and that's my advice, that the council actually take a vote as to whether or not this should be referred to the hearing officer. Now, some procedures are being developed by staff on this pursuant to statute. Those, I think your issues will be addressed. That's why I don't think that there's any precedential value in whatever action the council takes on this particular application.
All right, thank you. And I had that one last question, and I think this probably will go to, again, either of you. So on the matter of the definition of contested case, our definition in our management procedures differs from the Administrative Procedures Act definition of contested case. And so do we have what is sort of the legal authority by which the council can have a different definition when this council's decisions are guided and controlled by the Administrative Procedures Act?
The Administrative Procedures Act is not a hard and fast rule. And I'm not so sure that even though there's some differences, that what we have here does not conform with the Administrative Procedures Act.
It is a different definition.
Yes, it is.
And so you're saying it's not binding at this moment. We don't need to worry. I
don't see that as being a defect.
Okay, thank you.
And by the way, under the Administrative Procedures Act, this is a contested case.
I don't think we have a substantive disagreement on that matter.
Yes.
But thank you for your clarification.
But that's why I'm not concerned. I understand that, but I think under either definition, it's contested.
Thank you.
Any further questions? Mr. Flynn?
Since this is a new process, I'd appreciate if the council and members of the public could get some idea about where, if it is referred to the hearing officer, what the process is from this point on.
Okay, wants to do that.
If we know,
I can take,
Well, we do.
and how long it will take and so forth.
well, answering your questions in reverse, I don't know how long it could take. My recommendation, my understanding, my way of thinking is that we have a subcommittee procedure in place that, absent the hearing officer ever being assigned to CRMC, we would be following the subcommittee procedures as outlined in the management procedures, which means that the subcommittee would be formed. The subcommittee would set up a schedule. The subcommittee would hold hearings in the town affected. Aquaculture, we defer to the town of Tiverton since it's off the shores of Tiverton, even though it's in state waters. And a schedule will be set up from that point forward. So the hearing officer, in my opinion, should basically follow what we have in the management procedures for how a subcommittee would handle a contested case. At the end of that process, however long it will take to exhaust the evidence gathered for the matter, the hearing officer would make a recommendation to you all, like a subcommittee would, and bring the matter back up here.
So, Mr. Flynn, and I'm sorry, Mr. Gomez, the hearing officer, in addition to what Jeff said, and I agree with everything he said, he also is guided by section 46-23-20.3 of the general laws, and that's the pre-hearing procedure. And what the hearing officer can do is, prior to the commencement of any hearing, the hearing officer may, in his or her discretion, direct the parties or their attorneys to appear before him or her for such conferences as shall be necessary. At the conferences, the hearing officer may order any party to file, prior to the commencement of any formal hearing, exhibits that the party intends to use at the hearing, and the names and addresses of witnesses that the party intends to produce in its direct case, together with a short statement of testimony of each witness. Following entry of an order, a party shall not be permitted, except in the discretion of the hearing officer, to introduce evidence in the party's direct case, exhibits which are not filed in accordance with the order. At the conference, the hearing officer may designate a date before which he or she requires any party to specify what issues are conceded. That would be an agreed statement of facts. And further proof of conceded issues shall not be required. The hearing officer shall also require the parties to simplify the issues, to consider admissions of fact and of documents which will avoid unnecessary proof, and to limit the number of expert witnesses. The hearing officer shall enter an order reciting the concessions and agreements made by the parties, and shall enter an order on such other matters as are pertinent to the conduct of the hearing, and unless modified, the hearing shall be conducted by order. The hearing officer may also order the parties to file, prior to the commencement of any hearing, the testimony of any or all of their respective witnesses, and to submit the testimony to the hearing officer in the opposing party or the opposing counsel by such date as the hearing officer shall determine. The witness shall testify under oath, and all testimony shall be in the question and answer format. Save for good cause shown, the testimony shall be the direct examination of the witness, provided, however, that the witness shall be available at the hearing for cross-examination by the opposing party or the opposing counsel. And by the way, council members shall have, this is by statute, section 46-23-20.5. Council members shall have no communication directly or indirectly with a hearing officer related to any issue of fact or law or any matter then pending before the hearing officer. The hearing officer also has under section 46-23-20.6. I won't read the statute because it's a little bit longer. But the hearing officer can issue subpoenas and summonses and things of that nature. So it's not a court proceeding, but there is some formality involved in it. The statutes contemplate a streamlined process where the parties will have an opportunity to file documents, make agreed statement of facts, so that when the hearing takes place, which will be in a Q&A format, there is an ability to cross-examine witnesses so they can go from there. The executive director is correct. At that point, the hearing officer will make a report to the council, and then the final decision will be here.
So we get a cut at the results of the.
That's correct, yes.
And we can accept or reject.
That's correct, yes.
I assume if you support one, I mean, probably the case is over, but, okay, and the other thing that bothers me a little bit on this, is we're into the fourth year, of coming up on our fourth year on this application. And, we're kind of changing the rules for the applicant by the addition now of a hearing officer we haven't had for, I don't know, a long time, 3-4 years, a while. And I don't have any problem with that, but I have a problem of being hung out for 4 years, and then all of a sudden we change the rules to the game.
Actually, those rules were, the statutes I'm reciting, they've always been in.
I understand
The
that.
question was, there was no hearing officer, but the funding came in and the appointment was made. We're taking a look at it. I think Ms. Robinson Hall has pointed out that this is something we should be doing. It's not a new issue for this board.
Yeah, I agree.
And here we are. So
I agree with her.
Yes.
Except it's 4 years already to get to this point, and like we're cutting off on a tangent here, in my opinion. But I understand all you read. I agree with all of that. I just think that this is an unusual transition, I guess, from one process to a different process.
correct.
But we do get another bite at the apple after the hearing.
Yes.
And approximately, somebody asked, I think it was this fall, how long knows somebody, how long would we expect such hearings to take place?
Well, I will say this, based on my experience with having subcommittees, particularly the one down in Potter's Pond,
Yes.
Getting everybody together was a difficult thing. I think one of the reasons why there is a hearing officer who's dedicated full-time to this will actually streamline the process and make it go along a little bit quicker than it has historically with subcommittees and even hearings before this council.
Yeah, and my understanding of where we sit now, legal counsel is telling us that we should be turning this over to the hearing officer and let those regulations apply. And does the council need to vote on whether we do that or not?
Yes, in my opinion, yes. Reasonable minds can differ.
I'm good plums.
Any further questions from the council? Yes, Mr. Gagnon.
I want to confirm this hearing officer doesn't have any other cases in front of it. We'll be able to get right on this. There's no backlog. You can. The only case right now that he has to work on.
The statute says unless otherwise occupied, then it goes to a subcommittee. The hearing officer is not otherwise occupied. He is doing contested fine hearings, but that does not prevent him from hearing this matter in a timely and expeditious fashion.
Thank you.
Any further questions from the council of Mr. Willis or Attorney DeSisto? The council in a position to make a motion based on comments and discussions made.
Make a motion to refer the matter to hearing officer.
The motion.
No, I think the referral is enough.
The motion has been made by Mr. Russolino. Is there a second?
Second.
Seconded by Mr. Gagnon. Any discussion? Hearing none, I'll poll the council. Mr. Russolino?
Aye.
Ms. Hall?
Aye.
Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
Mr. Flynn?
Aye.
Mr. Izzy?
Aye.
Mr. Gomez?
Nay.
I, Raymond Coyer, vote aye. So the matter will be referred to our hearing officer for hearings consistent with the statute. Right.
You want to give some time for the people to exit?
5 minutes. Yeah, we can do that. We can take a 5-minute recess to allow the public to leave.
You do.
Yeah, we do. We've got another proposed rulemaking. of the Coastal Resources Management Council. Next matter on the agenda is public hearing on proposed rulemaking under the management procedures 650-RICR-10-00-1, seeking to amend section 1.1.4.15 to reference the administrative penalty matrix guidance for violations of the Rhode Island Coastal Resources Management Program within the state of Rhode Island. And Bruce has this one, correct?
Yes, he does.
Welcome again.
All right, good evening, Bruce Lofgren, Coastal Policy Analyst. We have two proposed rulemaking items tonight. One is, they're both related to the administrative penalty matrix. One is of the management procedures in section 650 IRCR 10-00-1. And the other is in the red book, 650 IRCR 20-00-1. So what we have tonight is this is the public notice period. We posted the public notice on October 26th. It runs until November 26th. So we're required to hold a public hearing for anyone from the public who would like to submit comments here in person tonight. So far, I have not received any official public comments via email or the state website, just a few questions and a little correspondence.
Okay,
Is this on the,
It is. yeah.
number 5 on the agenda. We'll open up for public comment. Is there anyone in the public that wishes to speak on this agenda item?
No. That matter's been resolved. This is a rule change. And it's a public hearing. Would you like to speak on it? It's a rule.
Speak on the point, yeah.
That matter's over. We're on the next item on the agenda.
So what happened with those?
Got referred to a hearing officer.
Oh, okay. That's what it is.
Yes.
Well, thank you very much.
No, thank
Okay.
you.
Does Mrs. Gomez want to say something? On the hearing, on the-
It's Mr.
Yes.
How was the young lady in the back?
she can move up, put your hand, swear you in. We know that you are used to swearing.
We want to put you on the road and we're going to ask you questions about Don. Go into, we cleared the room. We got all night. Jeff's got 3 hours. He said he was going to be at. All right.
Marry an older woman.
But it looks like no public comment present this evening on this particular item. I don't think we need a vote for my conversation with Jeff. We just opened it and we closed public comment for tonight. That's correct. Correct?
Yes, that's correct.
Anything further on the agenda to come before the council?
There is not, Mr. Chair.
Entertain a motion to adjourn. Motion made and seconded. All in favor, say aye. Aye. Anyone opposed? Motion carries. Meeting adjourned. The good product.